Well, good morning to folks out here on the West Coast, and good afternoon to people on the East Coast. I'm sure everybody stayed up watching the baseball game last night. So we got a Game 7 with the Cubs and Indians, which should be exciting. I'm Ryan Thurman with Contact Center Compliance. Today with me I have Eric Allen with Allen, Mitchell, and Allen. He's one of the legal partners we work with in terms of helping folks understand some of the complexities around TCPA, FCC rules, FTC rules. We're going to spend about a half hour, 45 minutes talking about some of the hot topics going on in the regulatory world, including the most recent petition, kind of oral arguments, some of the key cases. We're going to talk a little bit about some of the TCPA compliance solutions that we provide and how we help clients manage some of the riskier practices that are out there and avoid fines. And what we're going to do is have this call recorded so that folks that can't join or join late can get access to that, so we'll send that out after the webinar. And then what we're also going to do is put together the slide deck, so you'll be able to download that as well, so you don't have to take notes the whole time. There's also a question and answer tab on GoToMeeting, and as we go through the webinar today, feel free to ask questions. And then at the end, we're going to probably spend a good 20-30 minutes trying to answer folks' questions. Other than that, I'm going to introduce our today's speaker. Again, Eric Allen. I'm pleased to have him on board. We just did a compliance summit down in Carlsbad together, so I got to hear a little bit of preview of the webinar today. We're also putting on another compliance summit that I'll talk a little more about later, December 6th in Clearwater. We've got a special promo for webinar folks. If you stick around, I'll get you the info. But turn that over to Eric, and he's going to kick us off today on our webinar on TCPA and contact center law and what's on the horizon.
Thank you, Ryan. Always a pleasure. That was real great in Carlsbad last week.
Eric, you with us?
The next one. Yeah. Can you hear me? Ryan? Ryan? Ryan?
Yeah, I can hear you now.
Can you hear me?
I think you're on mute or something. Okay, good.
I apologize.
Yeah, my heart racing there for a couple minutes. I'm like,
I was scrambling to find my cell phone and the number. Yeah.
Great.
In any case, I'm Eric Allen with Allen, Mitchell, and Allen. We've got a law firm in Salt Lake City with a national practice in federal contact center law. We have a practice focused exclusively on advising and defending call centers, telemarketers, dialer vendors, and lead generators. So today we'll start out by talking about, first of all, the difference between the FTC, Federal Trade Commission, and FCC, Federal Communications Commission. Also, we've got all these states and some state call center type laws. What's the difference? Why all these agencies? Is there crossover? Do they have different jurisdiction? What's the deal? So first, the big bad FCC and their TCPA, the Telephone Consumer Protection Act. That is a statute passed by Congress, but Congress also authorized the FCC to create additional administrative rules and regulations to flesh out and kind of define and clarify the TCPA statute itself. The FCC can fine companies up to $16,000 per violation. But surprisingly, that's not really the big TCPA threat. By far, the big deal in terms of the FCC and TCPA is this private right of action. A private right of action is when a law contains a provision that allows an individual person, a consumer, to file suit on their own against a company, either alone or in a class action, and obtain damages or an injunction, or both. And that is the big threat in terms of call center law today. It has been for a number of years and will continue to be probably the largest threat in this space in terms of legal risk. Consumers who sue companies under the TCPA can obtain up to $1,500 per violation, so per call, for example. And the FCC has very broad jurisdiction over virtually all telecommunications activities. The FTC, by comparison, the Federal Trade Commission, has its TSR, the Telemarketing Sales Rule. That's not a statute. It's a regulation that they created and passed with authority from Congress. As of as of August the 1st of this year, the fine for violating the FTC's TSR or any of the other FTC consumer protection rules is now $40,000 a pop. Pretty scary. But the nice thing is, well, two things, two positive things with FTC. One, there is no private right of action, meaning an individual consumer cannot sue you under the FTC's TSR like they could under the FCC's TCPA. That's nice. That means only the government can enforce the TSR. The FTC would need to sue or fine you, and they, of course, are traditionally concerned with the biggest, baddest, highest volume offenders, companies that are generating dozens or usually hundreds or thousands of complaints. The low-hanging fruit, so to speak. Also, the FTC has a much more limited amount of jurisdiction than the FCC. For example, there are certain special kind of hands-off industries that the FTC is not supposed to touch. Those include insurance companies, banks, airlines and other common carriers, telephone companies, charities and other types of nonprofits. So while the FCC does have jurisdiction over calls made by a nonprofit or a bank or an insurance company or an airline, the FTC does not. If you're in one of those special industries, if you're an insurance company or a big bank or an airline, for example, or a nonprofit entity, then you are, as a general rule, completely outside the jurisdiction of the FTC and its TSR. But you still need to follow FCC rules. Also, if you hire, for example, a vendor who is not the insurance company or who is not the nonprofit, etc., then all of a sudden your vendor might be subject to the FTC and their TSR. Don't forget the states. Of course, we have 50 state attorney general offices or similar agencies. In a lot of states, there is a division of consumer protection that's either part of the local AG or local Department of Justice or sometimes part of the Department of Corporations or similar branch. Let's now do a quick recap on the TCPA and TSR. First, a text is a call. A lot of folks on this webinar probably engage in some form of SMS, either marketing or informational campaigns. A text is treated essentially the same as a call. The feds have made that clear for a number of years now. The rules differ depending upon whether your message, text or call, is telemarketing or non-marketing. Different rules apply. More rules apply if you're marketing, if you're promoting, or if you're selling, than if you are merely sending a delivery confirmation or a survey or collecting on a debt, for example. Here's a big rule from the TCPA, and there's a similar rule in the TSR. You cannot use an auto dialer to call a cell phone, and you can read in text, so to call or text a cell phone without prior express consent. And if your message is marketing, that consent has to be in writing, express written consent. Well, what is an auto dialer? An auto dialer, automatic telephone dialing system, or ATDS for short, is defined very broadly by the FCC, as you probably have heard. They have put out over the last handful of years a number of different confusing, sometimes conflicting definitions, the most recent of which in writing was in July of last year when they put out a new report and order responding to a number of petitions requesting clarifications about what a dialer is and what a dialer is not. Here is a big trigger. Of course, we know that every predictive dialer is an auto dialer according to the FCC. Anything that can dial without human intervention automatically is an auto dialer according to the FCC. But here's kind of a new trigger from July of last year. This is this potential or future dialer capacity trigger. Last year, the FCC said specifically, unfortunately, that even if your dialing platform isn't actually being used in some sort of predictive or auto dialer mode, if it has the capacity or even, and this is from July of last year, the potential or future capacity to auto dial, that makes it an auto dialer. It's an auto dialer now if it has the potential to auto dial, meaning if it could quickly, cheaply be upgraded, if you could flip a switch or do something very quick in the settings, etc., to make it auto dial if you told it to, then it is an auto dialer, which is kind of a silly rule because you think it should matter how you're using the platform, how you're using the software, not the capacity in the software code, not the future capacity, what you could do or download or upgrade it to do. Kind of a silly law. It's being challenged, of course, in court. We'll talk about that. Bottom line is, and the FCC has emphasized this numerous times lately, anything that can dial, quote unquote, thousands of numbers in a short period of time, the FCC is likely going to consider an auto dialer. What does that mean? What is a short period of time? They didn't say. Some other rules. Remember, for a non-marketing call, you only need express consent to auto dial a cell phone. And that can be implied if the person gave their number to the business. We'll talk a little bit more about that. But remember that. There's this very strict written consent you need to send an auto-dialed marketing call, but the standard is a little lower for a non-marketing call. You only need this, I know it's a bit of an oxymoron, but this implied express consent from the provision of the number, or it could be oral consent, etc. A consumer may revoke their prior consent at any time, and according to the FCC in July of last year, they can revoke in any reasonable manner. Well, the FCC argues that means you can't force the consumer to opt out a certain particular way, like sending a written notice with return receipt requested to a particular address, etc. They don't like you to be able to condition it in that way necessarily. You have to honor any reasonable request, no matter the medium, time, or place. If it's reasonable, you need to honor that opt-out. Well, who's the call-out party? Let's say you have a list. Maybe it's an opt-in consent list of people who provided their number. Maybe you're a creditor and you have all these telephone numbers collected on loan application documents filled out and signed by the debtors. Well, let's say you're calling trying to reach person A. Who is the called party? All these laws that talk about the called party. You can't auto-dial a cell phone without consent of the called party, etc. Who is that called party? Is the person you're trying to reach the intended recipient? Unfortunately, no. The FCC clarified last year that that called party is a subscriber or customary user, not the intended recipient. That's kind of a bummer because if you call trying to reach person A who gave you permission to call or gave you the number, and you reach person B, that's a violation. Now you get one free pass, the Fed said last year. As of last year, we get one free pass, but that's not super helpful because they might not pick up the phone and tell you wrong number till the 20th call. Well, that's 19 violations. You're constructively put on notice. You're expected to know that it's a wrong number after the first call, even if they don't answer, or even if you text and they don't reply, or if they hang up. What does that mean? Well, you need to be doing some form of reassigned number, call verification type scrubbing. We'll talk about that. There were some new special limited exemptions created as of July of last year for certain time-sensitive healthcare and financial alerts. This is like a fraud alert, for example, from your bank. They get some breaks from these written consent rules. And there are other behavior rules, of course. Time of day or curfew rules. The federal standard is that you can't call except between 8 and 9, for example. Some TSR amendments this year. I mentioned this, but effective August 1st, the fine is now $40,000. That actually wasn't a TSR amendment. That was an amendment to other regulations that affect the TSR, the Can Spam Act, the Restore Online Shoppers Confidence Act, and a number of other regulations enforced by the FTC. So 40 grand a pop. Used to be 16 grand. They said, you know what? We need to catch up with inflation. Now our fine is 40 grand a call. Kind of spooky. So just make sure you're in compliance and avoid that. Effective in June of this year, they had banned a bunch of kind of more aggressive payment mechanisms. Those are listed here. For example, cash reload mechanisms. Effective February 12th, we got a bunch of new rules. The two I'll mention are, and I've underlined these. First, the TSR now has an affirmative obligation that sellers and telemarketers must have documentation, must have proof if they have consent or an established business relationship exempting them from scrubbing against the national do not call list. Well, duh, the burden of proof's always been on the marketer. What's changed? Well, what's changed is it's now a separate independent requirement, meaning it's a separate violation, the way I read it, for you to not have the proof. So let's say you have an EBR relationship with a customer that allows you to call them if they're on the national do not call list for a period of time based on their consent, or based on their purchase or inquiry. But guess what? If you don't have proof of that, that's an independent violation, and you could have violated the TSR even if you had an EBR and were allowed to call them on the D&C list. It's a violation not to have proof of that exemption. Also underlined here, second from the last bullet point, the amendment effective in February of this year clarifies that a so-called B2B call is not really a B2B call if you're really trying to sell something to the individual employees. It has to be a product sold and purchased by the business itself. So if you think you're B2B because you're calling business lines, but then you're really trying to sell individual financial, investment, or insurance products to the employees, that's not truly B2B, and you're subject to the TSR. Okay, quick TCPA update. A lot of the actual changes to the TCPA took place in October of 2013 and then July of last year, but some relevant FCC and congressional stuff is listed here. For example, at the end of last year, Congress passed this Budget Act. As part of that, they chose to exempt themselves from the TCPA written consent requirement, at least for calls made to collect a debt owned or insured by the government. So this would be certain government-backed student loans, for example, tax debt, certain government-backed mortgages, for example. They kind of writ themselves out of the this written auto dialer rule. Also, and this isn't perfectly consistent, but the FCC put out a declaratory ruling in response to, I want to say, 2 or 3 petitions from government contractors. This is July of this year. They put out this ruling saying, you know what, we've read your petitions, you third-party private government contractors, and you know what, you're going to be exempt. If you're performing a function for the government, authorized by the government, acting within the authority delegated to you by the government, if you follow certain other behavioral rules that I won't go into here, but you're basically going to be exempt from the TCPA, and that's broader than just debt collection type calls on government debt. But it's a little confusing because there are these new kind of behavioral rules put into place by the FCC, and we're still not sure exactly how these two things jive and whether the one affects the other or how they affect the other, for example. Also, and this is very new, this was a lawsuit, or 8 lawsuits I should say, filed against the FCC shortly after their ruling last year about what an auto dialer is and future capacity and revocation of consent and called party and reassigned numbers. Some of these really harsh kind of interpretations that came out last year were challenged in court. The ACA, PACE, SiriusXM, a number of other big brands and trade associations, 8 of them in total, each sued the FCC. Those were all consolidated and are being heard as part of one combined case in the federal D.C. Circuit Court of Appeals.
Hey, Eric, that's probably a good time to take a quick poll on what people's ideas are in terms of possible TCPA reform. Whether you think it's going to be positive, they're going to make the rules worse, or you just have no idea and you hear about TCPA maybe for the first time, which would be odd.
Yeah, let's do a poll.
Everybody, so it looks like about 44%. Let's see here.
So we've got 108 attendees, and the question was what?
So we got about Actually, most people think it's going to be negative. It's going to be worse.
Interesting. I may
That
have a
actually is
positive
surprising.
spin, a silver lining.
Yeah,
Yeah. There's been a lot of doom and gloom the last couple of years in terms of TCPA, but I think there are some silver linings. I think 2017 might actually be a little better than the last couple of years. I'll explain why. So we've got this big lawsuit, 8 lawsuits in one, against the FCC over a lot of these new harsh rules. That lawsuit was fully briefed, meaning each side, the FCC and the attorneys for the industry, have each filed written arguments with the court back and forth, and then there was an oral argument held just a couple weeks ago on October the 20th. Fascinating. I want to say it was 2, maybe 3 hours, just hearing these DC Circuit Court judges grill the FCC attorney about some of these issues. Fascinating. I'll get into that. Also, we had the Spokio decision earlier this year that provides TCPA defendants with a new line of attack. Your Honor, this plaintiff has no concrete, particularized harm. They didn't really suffer. This is a technical violation. They don't have any damages. They shouldn't get to sue in federal court. This is interesting. This goes back to that oral argument, the October 20 oral argument. Now, this isn't binding or official or anything. This isn't in writing, but I'm probably going to cite this in some emails at least, and when I answer client questions about what a dialer is. So this is during that 3-hour hearing, the oral argument in D.C. a couple weeks ago. These judges are just grilling both sides really, but especially the FCC attorney who's trying to explain what a dialer is and how companies are supposed to know a number's reassigned just from calling it once and some of these silly rules. And one of the things near the end of that hearing they kind of forced this FCC lawyer to do was give the simplest explanation of what a dialer is possible. You've got all these orders over the last handful of years and amendments and rulings, each saying what a dialer is from the FCC, and they're inconsistent, they conflict, and they're very confusing and vague. Well, this is what he said, and he said this is what I think is the synthesis from all these different statements we at the FCC have made about what a dialer is over the last handful of years. I think a dialer is, and he said this, and this is pretty much word for word. I was writing it down as quickly as I could. I apologize if I omitted a word or something. But he said, a dialer is any device that can store or produce numbers at random, sequentially, or from a fixed list or database, and can dial those numbers automatically without human intervention. He said, I think that incorporates all of the elements you'll see mentioned in those orders. And it captures, and this was word for word, technology that can dial thousands of numbers in a short period of time and thereby lends itself to pernicious uses. They think efficient technology lends itself to pernicious use, which maybe we take issue with that. But that's really interesting. Here's just this few-line definition of what this FCC lawyer, this from October the 20th, thinks a dialer is. Any device that can store or produce numbers at random, sequentially, or from a list, and can dial them automatically without human intervention. They've tried to salvage their definition by kind of combining them all into one. They didn't say this. They didn't have a nice, clean, synthesized definition like this in any of their written orders, including the one from July of last year. And certainly this still may be somewhat vague. What does it mean to produce numbers? What does it mean to dial automatically? What is human intervention exactly? So still some vagueness. But it's interesting. So I'll go back once more. I would look at this when you're looking at your system and trying to decide whether it's an auto dialer or not, trying to decide whether you need consent to call a cell phone or not. Some recent positive cases, and this, I could have put 20 cases on this slide, but these are some cases. I believe most are all from this year, including an M-Gage one from just within the last month, I think. These are, this is kind of a silver lining. A lot of the cases coming out, admittedly, are in favor of the plaintiffs. You see big, giant settlements almost every week against some big U.S. brand or their vendors for dialer mistakes or cell phone mistakes or D&C related mistakes. But the ones you don't hear about so much are the ones we win. A lot of cases, again, this is just a very, very small sample. The first two are dialer cases, CBE and Mgage. These were cases where the company in both cases had some sort of preview manual clicker type platform where there was human intervention involved to transmit the message or messages in the Mgage case. And the court said no, even under the FCC's very broad definition and future capacity and all this, this is not a dialer. This is manual calling. I don't buy this plaintiff that this is a dialer, even under this very expansive, broad definition that the FCC has tried to give us. The Lincoln Automotive case was about revocation. This is a case where the plaintiff bought a car and didn't pay and was in collections and sued the collector, and the collector said, you know what, no, we had consent to call you. You gave us your number when you applied for financing, and there was also some great consent language on that form. You gave us consent. He said, no, 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 I may have done that, but I revoked consent. I'm promising you, Your Honor, that I mailed a letter into this company revoking my prior consent. And he even produced kind of a form, kind of template letter. It wasn't signed. It didn't have the right company or address on it. He had no proof of mailing or anything, but he said, I'm telling you, Your Honor, I revoked consent. So all the calls after that were a violation. Court said, nope, don't buy it. You don't have any proof. I don't believe you revoked consent. Case over. The Bayston case was about prior express consent. Goes to show that this is still alive and well. This is for non-marketing calls, of course. This is a case where I think this was I think in this case the debtor was like a patient at a hospital or clinic, and they had given their number to the healthcare provider who had passed it to their third-party collector, and the collector was calling, and sure enough the judge says, yeah, you know what, this is express consent to auto-dial itself for non-marketing purposes, and even though they didn't give it to the third-party collector, they gave it to the hospital, I think it passes in this case. Of course, we talked about Spokio. In Spokio, the court ruled that plaintiffs in cases like TCPA and other similar consumer protection cases based on federal statutes with private rights of action, they need actual concrete harm, not little technical injuries. You need damages. You need concrete, particularized harm. We've seen a lot of cases since Spokio go both ways. In some cases, the judges are saying, yeah, plaintiff, you suffered no harm by this one phone call, get out of here. We've seen other cases where the judge says, no, the TCPA is a privacy statute, and there is inherent privacy, concrete, particularized harm when you call someone at their home and interrupt them. But this Sarton case, Barry Sarton v. EKF Diagnostics, was a case after Spokio this year that relied on and cited Spokio and said, no, plaintiff, you don't have harm. You weren't really harmed by these phone calls. This is little technical law violations. Get out of here. So we're winning a lot of these cases. Don't just focus on the settlements and the losses. There are a lot of victories you don't hear about. Again, I could have put 20 cases on there just from this year. Okay, I promised you, Ryan, we'd talk briefly about political calls. We're in the middle of a heated election month. In an election year, a new president will be elected shortly and sworn in January. What about these political calls we're getting? Well, there are different flavors of political calls. There's kind of the informational, get out the vote calls. There are telefunding calls saying donate to this nonprofit PAC or whatever. But these are, in short, these are the rules about political calls, the federal rules. Calls made by or on behalf of a political nonprofit organization are generally exempt from the FCC and TCPA, except for the cell phone rule. Remember the cell phone rule. Even nonprofit political calls still need express consent to auto-dial a cell phone. So even if you're calling by or on behalf of a nonprofit entity, you still have to deal with cell phones. You need to scrub them out if you don't have consent. And this is that lower level of consent, though, is all you need. Express consent. Could be verbal, could be implied by the provision of the number from like the members of your organization or prior donors, for example. Next, political nonprofit entities are outside the jurisdiction of the FTC altogether. Remember that? On one of the first slides, we talked about how the FTC can't touch nonprofits. However, what about when the nonprofit hires a third-party vendor, a for-profit telefunder who's calling to raise money? Well, all of a sudden, that for-profit vendor is subject to the FTC and their TSR, including, unfortunately, the robocall prohibition. What's the implication? A for-profit telefunder vendor who's raising money for the political organization, but they themselves are not the nonprofit, they have to refrain from making any robocalls to landlines or cells without written consent. They also have to honor opt-outs and obey a handful of other behavioral rules listed here. Common sense stuff, no misreps, no cold robocalls, got to obey the curfew rules. And note that this last bullet point points out in a lot of states, including big states like California, for example, they have local laws that are even more restrictive. In California, where they have 2 local robocall bans, one of them has no exemption for nonprofits at all, including political nonprofits. You have to have a live agent intro before you play the pre-recorded message. So don't forget about state rules.
Hey, Eric, this is probably a good place to
yeah.
launch the next poll, which is kind of an interesting one, which is just real simple in terms of who everybody thinks is going to win the election. It's kind of heated back up, and I know Trump's been sued twice for TCPA. I'm sure he's got plenty of money to pay those cases off. So
he's in the middle of one of these texting ones right now.
So the results are coming in. It just should be interesting. There's a lot of folks I think have done voting. So let's see. Remember how to do this right. Close the poll, and then I have to share the election. Wow.
And this is who we think will win, right?
Yeah, who do you think will win?
Okay.
Pretty good margin. We actually got some others in there, so that would be cool. We'll see what happens.
What does it say? I don't see the results on my screen. What is
basically, you got 62% Clinton, 30% Trump, and 8% other.
Very interesting.
Let me hide that so we can go back to the presentation.
Thank you. So one thing Trump should have done is get consent before text blasting people. We should also avoid that mistake. Remember, whether you're telemarketing versus non-telemarketing will dictate what type of consent you need to auto-dial a cell phone or auto-text a cell phone or send a pre-recorded message. So for non-marketing and non-profit calls, you only need express consent. That can be implied. This comes from the FCC, something nice they did for us a few years back. Express consent can actually be implied when the person provided their number to the company in the normal course of business without conditions until they opt out. Know that the message you send later, the automated message, must be closely related to the reason the number was collected in the first place. Walgreens messed this up, arguably, and took a big class action in the last year. They were collecting cell phone numbers when people dropped off their prescriptions, and at least some of the time they were trained to say, if people ask why you need my number, oh, we only collect that so we can identify you in our system. That's how we kind of keep track of your file in our system. Well, really, they wanted to text you to say your prescription was ready. So they had conditioned the use of the number by the way they explained it, and there was a class action over that saying, well, you didn't really get implied consent, Walgreens, to send these prescription ready texts and other texts, because when you collected it, you kind of limited the use of the number by telling people that it was just how you identified them in the system, kept track of them. Marketing calls require express written consent. If your text has any marketing content or even promotional purpose, then you need written consent to auto-dial a cell phone or send a text from an auto-dialer to a cell phone. Written consent, this is how you get it. Your consent language, and you get this through a number of different modes and mediums, online, on a recorded telephone call or IVR, or email, text, on a paper form, entry forms. But it needs to be telephone number specific, it's got to be purpose specific, it's got to tell them which business or businesses will call, it's technology specific, you've got to tell them you're going to use a dialer or text or whatever, as may be the case, and you have to specifically tell them they're not required to consent to your marketing in order to buy. Finally, you need to collect a clear, unambiguous, affirmative consent and signature or electronic signature or some affirmative act that could constitute that, like clicking a checkbox or clicking submit button after proper disclosures. Here's a sample. Don't just cut and paste this. Talk to your own counsel and look at your specific situation, but here's something that I think would work in most cases. By clicking Submit, I agree to be contacted by Allen Legal, along with its agents and partners at the number I entered above, which I certify is my own number for marketing and other purposes, including through the possible use of an auto dialer, pre-recorded, and text messages. I agree that calls may be recorded. I'll update Allen Legal if my number changes, and I understand I'm not required to consent in order to purchase. Submit. If you're capturing on the website, be sure you've got good record keeping. Capture the URL, time and date stamp, IP address. Occasionally get a screenshot so you can prove what disclosures were up. Store all of that, I would say, for at least 5 years beyond the last day you will call in reliance on that consent. We're almost done here, guys.
Hey, Eric, before we jump into that, let's
yeah.
take a quick survey on terms of how people are actually obtaining consent. Because there are a few different ways out there. So I've got we got website capture, oral capture through representative, voice recording, or other.
This should be interesting.
It should, yeah. I mean, we get some good insight on these.
While people are voting, remember you cannot get consent for future automated calls merely by capturing their number or doing skip tracing or something like that. They have to voluntarily provide it to you, read it to you, type it in, etc. after proper disclosure.
Let's go ahead and close the poll, and then let me share the poll. I think I got the hang of this now. So we got 55% web capture was the top, and then close behind was oral capture through representative, and then voice recording, 35%.
Oh, wow. A lot more people are doing that.
Yeah, 35% voice recording and 15% of other.
Interesting.
That is actually very interesting. So it's kind of a mixed bag.
I get that question a lot. Eric, my process doesn't allow me to get ink on paper or website click, but I take inbounds. Can't I collect written consent somehow on that inbound call, or if it's an IVR or something? Yes, you can. If you do it right and you have the right disclosures and record keeping, you absolutely can. What is on the horizon for next year? Well, a number of things. These are my predictions. I predict we'll get a new president in January. I guess it's not much of a prediction. That's a fact. But no matter what your politics are, we're getting a new president. That person will likely have different pet projects, different views of some of these issues to the extent that they get involved in this telemarketing stuff. That's not perfectly clear, but one thing is certain. The president has the authority to appoint the commissioners on the FCC. Right now we have 5 commissioners, split right down party lines, 3-2. And the new president, whoever he or she may be, gets to A, immediately pick the new chair of the commission. They don't just get to dump the commissioners and appoint new ones, but they get to choose which of the 5 are the chair. That person has a lot of power on the commission. Also, they get to appoint new commissioners as the old commissioners as their terms expire. I want to say we have at least 1, maybe 2 commissioners, 2 of the 5 expiring in 2017. Whoever the new president is will get to appoint their successors. Interesting. New commissioners on the FCC means a new dynamic. Again, new pet projects, new interests, new feelings about some of these issues. We know that on a lot of these new FCC rules and interpretations, they've been hotly debated and contested within the FCC itself. Some of the commissioners being very, very upset at other commissioners for the rules that were put out. I suspect in 2017 we will get new regulatory feedback, maybe not rules or laws, but we will get new positions, new feedback on some of these new technologies. For example, there have been some rumors, and yes, we will be getting some new FTC comment regarding avatar or soundboard technology in the very near future, possibly even late this year or early next. I suspect if we start getting complaints about ringless voicemail drop or multi-line preview, some of these other new cutting-edge technologies, that we will start to get some feedback from the regulators on those issues. Certainly, I think the FCC is going to take action on avatar. The FCC has indicated they are getting a lot of complaints about that technology from some who are misusing it, abusing it. We will get new low-level kind of court decisions and also higher-level appellate decisions on dialing platforms, my suspicion is actually mostly positive. I think in 2017, most but not all, I think of these preview platforms will be upheld in some form or fashion by a lot of different courts. It's so tough because you could have one trial-level judge in one court in one state that thinks one platform is manual, not an auto dialer. And the same platform could be challenged in another judge's court in a different state, or maybe even the same courthouse in the room next door, and a different decision reached. But over time, throughout 2017, we're going to get a lot more decisions about what a dialer is and isn't. And I think a lot of these manual platforms are going to be upheld. I think they'll be considered manual as long as you're careful. Not all of them, certainly, but a lot of them. I think that's a trend. I think that's positive. The American Collections Association, the ACA, that big appeal where the ACA and the 7 other brands have sued the FCC, we're going to get a ruling in that case. Could be December, could be January, maybe February, but we're getting that very, very soon. What will that mean? Well, there are kind of 3 main things that lawsuit attacks. One is the definition of an auto dialer and the silly future capacity standard. One is the revocation of consent issue. How are companies really supposed to know or really supposed to be able to field an opt-out through any mode or medium received at any customer touch point? Shouldn't we be able to condition that? Also, the reassigned number issue, i.e. the called party issue. How is it that we can be held liable for calling person A who gave us consent when we don't know it was reassigned to person B? We don't yet have a reason to believe that. And the scrubs are not absolutely perfect, not yet anyway. I think we'll get something positive out of that case. I'm not saying the circuit court is going to just completely throw out all these rules, but maybe they put some, maybe they scale back a little bit on the future capacity standard, or maybe they get rid of this silly one free pass reassigned number thing and require companies to, or allow companies rather, to keep calling until they have actual knowledge of a reassignment. I don't know, but I think we'll get something positive out of that appeal. What? We don't know yet, but it's just, to me, it's inconceivable that we as an industry will lose on all those issues. I think we'll get something helpful. I'm hopeful anyway. Fingers crossed. And of course, Spokio, this new line of attack about arguing plaintiffs don't have concrete harm. We're going to get a lot more cases trying to, or a lot more defenses and motions to dismiss trying to throw cases out based on Spokio. I think we'll win some of those, not all certainly, but some of these, especially on some of these pro se cases where they don't know how to create their complaint properly to plead or state, allege in their complaint proper concrete harm. I think we will get some of these cases thrown out over Spokio and the harm-related arguments. I think that will be positive. Finally, with my last couple of minutes here before I hand it back over to Ryan, some compliance hacks for staying safe and mitigating risk in 2017. Here are my kind of final tips for the day. Ryan, I'm sure will pitch you on this, but no matter what vendor you use, I would encourage you to do a litigator scrub. There are guys out there who are sitting, who can't get a regular job like you and I, and they are waiting to sue you. They are waiting to trick your agent when you call. They want to rack up a lot of calls. This one gal bought, what, Ryan, 20, 30, 40 cell phones or something, burner phones, and just kept getting calls and calls and calls, and would rack up a bunch of calls and file suit, make a lot of money.
Yeah, that was the Melody Stoops.
Yeah. Traveled the world with the money she made off the TCPA. As she had to admit in her deposition, one judge has kind of basically kicked her out of his court, said TCPA doesn't protect you, Ms. Stoops. You do this for a living. Do a litigator scrub. You just don't want to call people like that. There are over 100,000 of these folks identified now, people who like to sue, people who have sued under the TCPA or similar statute before. You don't want these people ending up in your list. If they're already in there, you want to get them out. You don't want to risk it. Even if you think you're compliant, you don't want to call in these people because they'll make frivolous claims. Reassign number scrubbing. At least for now, we've got this problem where the feds say if you call person B, but you were trying to reach person A who had consent, you're liable after the first call. Even if they don't pick up an answer till 10, 20, 100 calls later, they're going to sue you. Do some reassigned number scrubbing. Reassigned number scrubbing, litigator scrubbing, you're not going to lose a ton of your data like you would to DNC and cell phones. You're going to lose 1 or 2% of your data or something. Ryan could tell you better, but this is not something that's going to kill your list. These are inexpensive things you can do to mitigate risk immediately, like today. Get those reassigned and wrong numbers out of your list. Get those litigators out of your database. Police your vendors. This is one of my big takeaways from 2016. It just no longer flies. You can't just say, oh, my vendor signed a contract to comply with the law, and I wasn't aware of any problems, so I'm not liable for what they do. That just doesn't fly anymore. People are getting sued every single day for their vendors' mistakes. The FTC is suing and holding companies and even their individual owners liable for the mistakes of the third-party vendors. Willful ignorance does not fly. You need to police your vendors. You need to act in good faith, find out what they're doing. Do they have a SAN number? Are they doing scrubbing? Where are they getting their data? Are they using a dialer? Are they honoring opt-outs? What are they really doing to generate those leads? Are they really consent leads? Press, press, press. Do your due diligence. Don't just take what your vendors tell you at face value. You're going to get sued. I said a lot of encouraging things about manual kind of preview platforms. I think most of the cases will go our way in 2017. But avoid platforms that still quack like a dialer. What I mean is be careful. I think there are some platforms out there that there is some form of human intervention mixed in somewhere in there, but really it's still a predictive dialer. Just be very careful. If you're having a lot of call abandonment, recorded message, if you're doing things that make you look like an auto dialer, you're going to get sued whether it's a dialer or not. Then you've got expenses and fees, win or lose. So be careful if you're trying to call cell phones from a manual dialer. Vet that carefully, both from a technology standpoint and a legal standpoint with your counsel. Here's a big one. Resolve all consumer complaints immediately and to the consumer's full satisfaction. That means issuing refunds even after the cancellation period expires. That means making apologies even when you know you're in the right. That means responding, bending over backwards right away, making people happy so they don't sue you, so they don't file complaints. Most people who sue are mad. Most people who file complaints with regulators are mad for some reason. Don't let your customers hang up the phone mad, and a lot of this risk goes away. TCPA insurance. Well, it does exist. It's new, it's hard to find, but if you shop around, you will find coverage for TCPA defense. Or some of these insurance carriers will, at least for an increased premium, delete the TCPA-specific exclusion in your policy that most corporate insurance policies have. Try and get those exclusions written out for TCPA. And where you can find it, get TCPA insurance or force your vendors to get it. Finally, stay in tune. I'm preaching to the choir here. Let's see, 106 people still on the line today. You're the ones that are coming out, staying up to date. I suspect you folks are the ones who are signed up to receive the alerts weekly from the FCC and FTC and CFPB and Ryan's company and my firm or other firms who put out legal alerts about law changes in cases and settlements and best practices. You're doing the right thing. Spread the word. Make sure you stay up to date. We are in a rapidly changing regulatory environment. New rules, new interpretations, new cases are coming out every day, or almost every day, certainly every week. Stay up to date, stay abreast, be dynamic, be the hero at your company by protecting your brand, by learning about that new interpretation and tweaking your dialer right away to avoid a class action or incorporating a new scrub to mitigate risk. Whatever it is, make sure you stay in tune. And with that, Ryan, again, it's been a pleasure. I'll hand it back over to you and Contact Center Compliance.
Thanks, Eric. Appreciate you breaking things down and kind of keeping things brief so we can have some time for some question and answers that a few of them come in. So feel free to get those going. In the meantime, I was going to give folks a little bit of a more overview of what we do compliance-wise, because we've had a lot of interest in a couple of products, specifically the one that Eric mentioned, our Litigator Scrub solution, as well as the product where we can identify and reassign cell phone numbers underneath the new FCC order, or newer FCC order, that has been very helpful in terms of mitigating risk with calling wrong numbers. Folks like the Melody Stoops, you want to go to the next slide, they're out there. They're filing multiple lawsuits a day against multiple companies. A lot of them are engineered cases from the onset where they're acting and posing as potential customers. I've heard stories where these guys will come out and even, opt into a timeshare presentation, go attend the mini vacation, get the free stay, collect a few texts and follow-up calls, and all of a sudden, not only did you give them a free stay, they're turning around and want to sue you for $20,000 or send you a demand letter. For attendees that are on the call, one of the things that will be real helpful is if you want to take a look at a snapshot of your data, run it through our analysis in terms of what we have on our litigator files. So say take 50,000 records, run a test. Happy to do that for you. We'll identify not only the number of litigators that could potentially be on your data, but also who some of these folks are. So a lot of them come up time and time again. Some of them are new. We pull from not only case filings, but reports that we get from attorneys like Eric and also from some of our own clients. So we've got a real good way to kind of peer in kind of pre-case, even with some of the folks that are newer in the litigation market. And we've got, I think, about 116,000 phone numbers now that are tied to litigation. So it's a pretty powerful way to kind of keep folks out of your shop. We also provide a solution for dealing with VoIP numbers. So we can help you with those kind of VoIP numbers that may now fall under TCPA with a couple of the recent cases where VoIP numbers have been subject to TCPA. It's hard to tell which ones are non-unlimited, unlimited. The point being, you most likely, if you want to fight a case, some of these VoIP numbers are now being used, or they're buying these, litigators are buying these limited VoIP plans in order to turn around and claim TCPA damages. So you might want to start flagging those elements in your data. And we also do scrub for ported cell phone numbers and carrier numbers. The interesting thing about the ported universe is the licensing is going to be transferred over in the next year or so to Telcordia and iConnective, and so Neustar will be no longer the kind of sole provider. The sole provider would now be under the new Telcordia relationship with the NEAPA switchover, so that should be hopefully pretty seamless, but remains to be seen. From what I hear, everything's going to kind of stay status quo until they kind of get the switchover handled, but that's supposed to happen in the end of 2017, beginning of 2018. I'm going to go to the next slide. Eric, I'll talk a little bit about wireless verification. So if you're getting consent from consumers for TCPA, you want to make sure you don't have reassigned phone numbers in there. I've seen reassigned rates, disconnect rates anywhere 5 to 10, 12% on files that we're running. We have a solution where we hit the telcos, basically the wireless carriers, through a live lookup. So we're doing an authoritative database match on those numbers to find the disconnects, but we're also able to score the data back so that on the numbers we do verify, we can tell you which ones are safe at a very high level for leaving on an ATDS or automated dialing system, but also those that are partial match it or unknowns that you might want to leave on a manual dial solution to try to avoid TCPA issues, which is pretty cool. We've got a quick turnaround. We're easy to work with. Again, we'll do some testing on that as well, typically with a client. So clients usually send us a file, 4,000 or 5,000 records. We'll run it, flag it, return it to them within an hour or two. It's a very simple way to kind of comply with that provision. Also clean up your data at the same time. We've also got some really good rates on this. If you shop around for verification, you're going to see some kind of mind-boggling rates that people will throw at you for this. So since we've got some, we've done a lot of research into how to run this. We've got some good ways to work with our clients on this. A lot of times with no commitment if you don't want to bring down the volume. On the next place we're going to be list, I mentioned earlier, we've got a summit down in Clearwater, Florida. It's quite nice in December, on December 6th at the Hyatt Regency on the beach down there. The code, we'll send this out in email as well, but I've got the link up there to the summit. It's also on dnc.com. The code for the discount, which is good for a rate of $200, which is quite a bit less than our normal rate, is just webinar. So if you go on there, want to sign up, we'd love to see you down in Florida. Should be a good event. We have a couple guest speakers. We have Christine Riley with Manat, Phelps and Phillips, and we also have Tanya Klauster coming from Wilson Sassini. So it should be a good event. We might also have a guest speaker from the FCC, as well as the event is also eligible for some continuing education credits for folks like PACE and CECP. So it's worthwhile. It's a day event. It goes from about 8:30 to 4:30. We do a reception thereafter. It's a good way to kind of get a little bit more than just sitting through some of our webinars, which we'll have this recorded and out to folks, so you can access it through our YouTube channel as well. Let's switch gears because I think there's enough questions where we can kind of have a pretty good discussion. So again, if you want to put some of those in, we got a few more minutes here. This one actually is a little involved, but it's I think we'll start with this one. This is the last one that came in. It says, any recent developments regarding how far back the chain of liability for TCPA/TSR violation goes, or go to data companies who provide telephone number data directly to sellers through their call centers for telemarketing purposes?
Great question. So what we know is that for the TCPA, that's the FCC's rule, the TCPA, plaintiffs can only go back 4 years from the date they sue. What does that mean? For TCPA purposes, you or your clients or somebody needs to be saving all of that data, I would say the telephone number data, if you're collecting opt-ins, all that consent data, if you're the one making the calls or you're the dialer vendor, the actual call logs or CDRs, etc. All of that I think you need to store for at least 4 years from the date a call is made. So you need to coordinate. If you're selling data to a seller or call center, you need to, I would say, store that for at least 4 years from that date. I'm going to say 5 in a minute because of the FTC, though. According to the FTC, though, the FTC itself can sue you going back for up to 5 years, rather. They have a 5-year statute of limitations on a government enforcement action under the TSR. So I would just say take the lowest common denominator, store everything. I mean everything, call recordings, logs, scripts, employee files, the raw data, opt-in consent data, store it all for at least 5 years is my opinion. I have some clients that will store it for 7. And that's a duty in terms of the chain of liability. I would say that's everyone's duty in the chain. If you're just the data broker or vendor or the lead generator, you want to store that data on your own to protect yourself if you get dragged into a suit years later and you need to prove your innocence. But also your client who you're selling the data to should be storing it also on their end, and also their own logs and stuff showing how they use that data to protect themselves from a case, a TCPA case that could come 4 years later, or a TSR case brought by the FTC that could come 5 years later.
That's a good answer. Let's ask a quick poll. I'm curious how many people have actually been targeted by some of the litigation that's out there that they've been sued. This is completely anonymous. We're just curious if how much
Does
these
this
folks
include like a demand letter also? Sued?
Yeah, demand letter, send me money.
Threats.
I never paid my bills for the last 5 years, but I still want you to pay me. So we got about a little over half. I think we did this poll last time. About a third of people, 30% or so, had seen some sort of TCPA activity at their organization. I know I'm hearing about more and more, and we obviously see this in our case tracking, but it just seems like everybody's got a story about somebody. Let's see. So we've got, let me close the poll, and let's show the surprise number there is 36%. So that's a decent number considering we've got about 100 or so people on the call. And then you've got 70% if somebody knows somebody that's been targeted. 40% and 7% no. What are you guys seeing at your office, Eric? There's been a big uptick in clients giving you...
Yeah, I mean, I would say virtually everyone we come in contact with has either their brand has been targeted or they know someone or they're close to someone in the industry who has been through that. So it's almost everybody has been a target or knows someone, is close to someone in the industry, one of their buddies or an affiliate vendor, et cetera, who's been targeted. It just really affects almost everyone in the space, or it will at some point.
Yeah, for sure. take another quick call or quick question, which is, we are a direct mailer, only take inbound calls. We don't make outbound calls. Does TCPA and/or DNC apply to us?
Not really, except if you do any sort of outbound limited callback, like overflow, or they left a message, you didn't get to them, be very, very careful. All of a sudden, that's an outbound call, and if it's made from a dialer to a cell phone, I'm hoping you got consent. Also, certain rules still apply, like the opt-out rule. Even if you're inbound only, you still have to have a process in place to honor and opt out. So there are a couple of those little behavioral rules that apply, but in general, the vast majority of these rules, the TCPA and TSR, apply to outbound calling. The dialer rules, the cell phone rules, the do not call list, that's all outbound stuff. If they pick up the phone and call you because they got your mailer or saw your infomercial or saw your website, whatever it is, they're calling you. It doesn't matter if you have a dialer in your office or not. They called you. It doesn't matter whether they're on their cell phone or not. They called you. But do be aware, watch out for those outbound callbacks. All of a sudden, that's an outbound call subject to all this TCPA stuff. And then, of course, honor an opt-out, because maybe you do want to call these people again someday. Maybe you're doing inbound now. You should still be building kind of a database of people who, even at the end of the inbound call, say, no, I'm not interested in you. Save those numbers, and if you start doing outbound someday, suppress them.
So let's take another quick question, since some of these are very particular. This one, say they call us sales-based, but they're waiting in queue, and we offer a callback instead of waiting in queue.
That's fine. So if I understand the question right, consumer makes an inbound call to a sales center. They don't have an agent ready, so they're played a message or treated to some sort of IVR or something saying, hey, we're busy, but we do want to sell you this weight loss pill. Can we call you back in up to 10 minutes or something? Yeah, you can absolutely do that, but make sure you're storing that consent. Have the right disclosures. If you're going to call them back through some sort of auto dialer, say that. Can we call you back at this number you called us on, including through the possible use of automated technology? Blah, 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 blah. You know, throw in the disclosures and make sure that's all recorded, and then you're golden. Absolutely.
Well, I really appreciate the insight today. I think we'll take one last quick poll just for fun, because TCPA is no laughing matter, and you definitely want to take it seriously if you get any sort of demand letter or any contact by a professional litigator. Certainly want to involve your legal counsel, make sure your compliance officer doesn't go on vacation, that kind of thing. But let's take a look at who's going to win the World Series tonight. I kind of lost a little interest once the Cubs beat my Giants, but it's a surprise we're at Game 7. So Cubs looked pretty crazy last night, but you know what? It's baseball. Anything can happen in a Game 7. So I appreciate everybody coming out to the webinar today or virtually attending. We'll get the slides out, recording, discount for next time, contact info, all that good stuff. And again, feel free to reach out to us if you guys want to run tests on litigators or reassigns. Might be a good way to connect. And let's take a look at the poll. Wow. That is actually interesting. Let me share the results. It looks like the Cubs are the favorites amongst our audience. Must have a lot of people in Chicago on the call. I know who some of the people here are rooting for, but it's going to be a good Game 7. So appreciate everybody's insight and their info.
Wins the game, Ryan.
Put your info back up there. So yeah, if you need anything there, we'll be in touch. Anything additional, Eric?
No, thank you all.
Have a great day.
Bye now.